Good evening to all the innovators and all the aspirants of patent agent examinations. A warm welcome to all of you in the preparation session for patent agent examination. I just wish to let you know that as the exam is nearly 4 or 5 months are left. It's very important to do a very systematic preparation for the examination. As we all know, examination consists basically of Indian Patent Act. It is very necessary to study the all the sections of the patent act, but sometimes it become like a little bit cumbersome for scientific people to understand all the like laws and sections of the Indian Patent Act. So it's very important that we study it in a very systematic way, like a process of patent filing, prosecution, the powers, the obligations, what are the kind of infringements that could take place. If we study in such a way that we will understand all the basic procedure as well as the formalities in a procedural system, like we do our research. So, in our research, whenever we conduct any research, one by one, we go through a certain process. Likewise, if we study the Indian Patent Act in such a way, like how to file a patent, how to prosecute it, and in between, we will understand all the sections, all the subsections that could be applied here to make it a legal document. Patent is totally a techno legal document, and how to prosecute a patent and everything. We have to study in such a way that it just become a process for us, not like just reading out the sections. So let's begin and let's make it a very interesting session so that all should enjoy. If you have any doubts, you can write in the comment section. I'll be very happy to answer your queries. And definitely we have to learn, we have to understand. We don't just like remember, try to remember things, because if we try to remember things, sometimes we may forget, and that will be very difficult for us. Let's start. It's totally very interesting to prepare for patent agent examination. So let's first see what is the syllabus, how to study, what is the pattern. So first we will study in the first slide of ours, where we will study about the exam structure. So here it consists of three parts. The first part is of 100 marks, and here we have to understand thoroughly the Patent Act and rules. There are many acts, many sections under the act, many rules under the act, and that is totally related with our process. So if we understand the process well, we can remember the sections, subsections, and rules. So this paper is of 2 hours. It consists of totally objective type multiple choice questions. Here you will get MCQs also. Here true and false questions are also there. In multiple choice questions, there is one important thing, is one or more than one options may be correct. So if you understand the process, you can answer it. It's very important that we shouldn't try to remember, try to mug it up, because it will be really cumbersome for us. So if it's very important, because like 4 or 5, suppose 4 options are there, it may be there for all four will be correct. So this is a tricky thing here that we need to solve. The paper 2 is also consisting of 100 marks, where there is interpretation of patent specification and drafting part is there. So here you will be given a big paragraph along with some drawings also. Somebody's research, somebody's innovation is described in a paragraph. We have to draft the claims, but before drafting, we have to understand the innovation very well. So here the major brilliancy that could be applied by all of you is like to understand what are the basic components of the innovation, how they are linked together, is it patentable. So here, whenever we study the patent acts and rules, we will also study the patentability and non-patentability. So this all will be applied in understanding the description. So we shouldn't be drafting in such a way that it become not patentable. Suppose, just for example, what we have studied in our section 3 earlier is any arrangement or assembly of devices is not patentable. Suppose somebody's description says that it is assembled but supporting each other in such a way We have to draft our claims in such a way that it must not look like an assembly rearrangement. It must be drafted in such a way that all the parts are supporting each other to make a unit invention to make it patentable. So it's all totally dependent on the drafting. How will you draft a patent application so that your chance of patentability will be more? So many things have to be kept in our mind while drafting the patent application, and you will be given a full description. Other thing in the paper too that is also very tricky and that need to be understood well is the descriptive case study based questions. You will be given a situation, and then it is said to solve the situation and write down the right strategy, right answers, right clues about like suppose x and y are fighting for infringement, how like x is wrong or y is wrong, how you will defend x in this way. But here also your act sections, subsections and rules apply that need to be understood. So you have to understand, you have to do some brainstorming, and you have to think where we can apply these sections, how we can defend. So you have to you have to be totally confident about it, and this could be done only when you have understood the act and rules well. Later on you can definitely need to remember, but remembrance is important only when you understand it very well. The third part, the third hurdle in becoming a patent agent is the viva voce. Viva is also consisting of questions that are somewhere case study based. So as we all had applied like faced the viva once, I will also share my own experiences in viva, what questions have been asked, how I answered them, because I have scored very well in viva. After scoring in paper 1 and paper 2 also I got good marks. So in viva I will tell you exactly what questions have been asked. So one by one we will study first we will go through the paper 1, then paper 2, and also I will consult something about the viva. So let's go through the paper 1, where we will study the mcqs and how to solve the mcqs. I'm giving you the exact paper. So just see here how it is there. I think it's visible to all of you. So just see here, it is of 100 marks. Sorry, it is of 100 marks. Time was 10:30 to 12:30 p.m. And you can see here this the paper was of three parts. Part A was 60 marks, part B was of 10 marks, and part C was of 30 marks. All questions were compulsory, and there was no negative marking. That was a very beneficial thing for all of us. So let's study in part A 60 marks questions. This is comparatively easy as compared to the other parts. This was suppose your question, first question. So part A was of 60 marks and there were 30 multiple choice questions. So each question was carrying 2 marks and there was no negative marking. So first question was, the section of the Patent Act refers to power of controller to make orders regarding substituents, means like substitution of applicant. Applicant can be changed. So this comes under the power of controller, and this power of controller comes under section 20. So whenever we study one by one, we will study that first we have studied the patent filing, applications, then we have studied the prosecution, publication, examination part, and then comes under power of controller. So it comes in the section 20. So whenever we study the act and rules, this will come. Again, the next question that I can say it a little bit tricky question. The condoning of delay or irregularity in procedure within the powers of the controller can be requested by way of filing what? So suppose if some irregularity has been done from the side of the applicant or from the side of the applicant's agent, then how to rectify that irregularity? So, there are many ways, but the important way is like this comes under Rule 6 and there is a petition. There is no Form 30 because Form 30 definitely it's filed whenever there is nothing available. That's right. But affidavit is also not there. Form 4 definitely not there. But these are all you can know. Like these are very confusing answers here. Even somebody can think of it could be affidavit. Somebody can think because form 4 is specially we file for like extension of time. Form 30 is filed when there is no form available. So there are like very minor differences among the answers, but it is done through a petition under 137. Clear? So petition under 137, rule 6 is there. So this like 137 is said what it is exactly given in the Indian Patent Act. Also there was a recent notification by the Indian Patent Office, is like whenever there is such kind of irregularity in procedure has been done. This was actually done because of one recent case also. So this is a petition. The simple answer is petition has to be filed under 137 as per the rule 6. So now the question number 3. So here, some questions would be there that might confuse you, but you have to be very very clear about it, like what it should be there. So whenever we study the Patent Act, always understand that laws and rules can never overlap. They are at their position, they are for certain procedure. So always remember the correct procedure related with that act and rule. So if we study in a very straight way, nothing to be think like any deviation must not be there. You shouldn't apply anything which is not there in the law, not there in the act, not there in the rule. So then answers would be correct. Another question we see is like application for revision of terms and condition of compulsory license can be filed under the provision of it's totally section 88. It's a very direct question. Sorry, just a minute. So it's a very direct question. Section 88 states the revision of terms and condition of compulsory license. Suppose compulsory license has been given, but those who have received it is not satisfied. Is like because terms and conditions are not appropriate and he cannot comply with that, he can request the patent office for revising the terms and conditions, and that is given in the section 88. Now another important question, I considered question number 4 as a very important question. How? We will see. An applicant is residing in UK, filing a patent application in India and claiming priority from the first application in UK. The term of patent granted in India will be what? So it's a very general term. Suppose someone is residing in UK and is filing a patent application in India. So here nothing is mentioned that it is a PCT application, it is a convention application, is nothing. So you have to just think, you have to just keep your thinking in the boundary what is written in the question. So the term of patent granted in India will be what? The term of patent will be from the date of filing of application in India. And what is the tenure? 20 years. So answer will be 20 years from the date of filing the application in India. Clear? So we never have to think of like 20 years from UK or something, because it is never written it is PCT, it is never written it is convention. So in the country where we file a patent application, we have to count the date of grant from the date of filing. Clear? So term will be from the date of filing in the country where we have filed our patent. So here there shouldn't be any confusion about it. The next question we are handling now. Ground for opposition to the restoration of a patent can be what? So opposition to the restaurant cannot be non-working here. Invention is already in public domain. No, it's not, because if it is already in the public domain, it must not have been granted. The third option, that is failure to pay the renewal fee, was intentional. Then restoration cannot be done. You know why patent expires? Why patent, it is considered to be lapsed? Lapsed patent means what? Whenever the grantee, the patentee, doesn't pay the renewal fee, then the patent is said to be lapsed. So how to restore a lapsed patent? We have to state that I have not paid the renewal fee, and that failure of paying the renewal fee was unintentional. Clear? So if it is intentional, then restoration will not be there. Okay. So law says that defense is what? I couldn't pay the renewal fee because it was not intentional. So ground for opposition to restoration could be what? Failure to pay the renewal fee was intentional. simply. So we have to understand it, and we have to choose the right answer. Now the time period for paying the renewal fee without extension as per section 142, it is all about renewal of patent after every year, is 3 months. Now this says another question comes under section 3D. 3D says what? Section 3D comes under the non-patentable invention, which says that any salt, isomer, any new ester, ether of the substance is not patentable unless it is significantly differ from the parent compound with respect to efficacy. So the answer is written here. A new ester of a known medicine with carboxylic acid chain is patentable if it shows significantly improved therapeutic efficacy than the said acid. It's a very direct question. So always remember what section 3, significant efficacy, that we always will keep in our mind. So we can solve this. Because what they say, if you improve solubility, if you improve melting point, anything you do, it is not patentable unless until you improve the efficacy. So always remember the word efficacy. Now the forms and fees are very important part of understanding the act and rule. What I suggest, we will separately study the forms part and fees part, because many questions come from there. So which form is required to be filed for expedited examination under section 11B? So always remember, uh, form 18 is for request for examination, 18A is for expedited examination. So rule and section, rule 24C and section 11B. So this you can actually speculate also. If you can remember that for examination, if it is form 18, for expedited it would be form 18A, means more than 18, expedited. Fine. So answer is form 18A. Another question: which of the following decisions or orders are appealable before IPAB? So section 15 and 16. This is written in the Patent Act, that you have to remember. But yeah, if we understand it also, we can definitely answer. Because while studying all the act and rules, we have to read like a story, we have to read like a procedure, and in between we have to apply the sections, rules, so that things will be set in our mind in such a way that our mind will respond well whenever some question has to be asked. So another thing, uh, the controller Another question: the controller neither shall refuse to grant a patent, nor a patent shall be revoked by reason only of any circumstances under section 35 and 37. It is written because here, uh, any circumstances, if it fall under section 35 and 37, then refusal is not be done by the controller. Clear? Another is section 29 and 31 and section 30 and 32. These four are not refusable. Only this 35 and 37 are there where refusal can be done. So your answer would be either A or B or both, means section 29, 31, 30 and 32. All four, the sections, whatever the things fall in between, controller can refuse them. But section 35 and 37 are not refusable. Clear? So A and B. Now comes grant of compulsory license for manufacture and export of patented pharmaceutical product to any country having insufficient or no manufacturing capacity in the pharmaceutical sector to address public health problems fall under which provision of the act? So it is like a compulsory license. You always remember, grant of compulsory license comes under section 92A. So you can remember compulsory license, actually this working compulsory license starts from section 84, goes up to section 94. So just we have studied about compulsory license, that if we have to revise the terms and conditions, it fall under section 88. Grant of compulsory license is there in the section 92A. So these are all linked. If we club some of the section and rules and combine it to state something, it is like, suppose if we are combining the sections and rules between 88 to 94, it is all about working of patent and compulsory licensing. So section 92A is the correct answer here. So again, question number 12. This is very important question. Is like the information that a patentee is required to submit regarding the extent to which the patented invention has been commercially used in India. So commercially used in India. So it's about working of the patent. So information a patentee has to furnish. Clear. So every time patentee has to furnish, after 3 years of getting the patent, like how the patented invention is like being affordable to the public of India. They are being manufactured in India, commercially used in India. So it comes under section 146 and rule 131. This is a very important section and rule. So some section and rule are so important that somewhere these are being asked in the case studies in paper 2 also. So in between, we can understand the basic important sections also. Another question: if the central government is of the opinion that the patent is against the public interest, then what has to be done? What could be done? Here you can actually find out the answer of this question. First option is central government has to pursue the patentee to withdraw the patent. Directly, government normally doesn't say anybody to do any task directly. So there is a proper procedure of that also. Third option: central government has no power to revoke the patent. No, central government has every powers. Then central government has to approach the IPAB. No, it's more than that, higher authority. So what could be the right answer? Yes, central government can revoke, but they give the opportunity of being heard. Means they can hear the uh, patentee. They can take the viewpoint of the patentee. They can make a declaration in the official gazette, and thereupon the patent shall be deemed to be revoked. So revocation will be done, but after hearing and after publication in the official gazette. So this is the official procedure of central government. So the answer would be the B. So somewhere you can find out the answers also. What could be there? But all these things are written in the Patent Act and rules very clearly. So if we understand them, the exact procedure one by one, it will be easy for us to answer. Another question: how the patent application can be withdrawn once request is filed under Rule 7 and 26. So withdrawn can be done by submitting Form 29. That is written. Now comes the section 25. Always remember the question number 15 says about section 25. Section 25 is what? It's the opposition. So opposition, pre-grant and post-grants all are coming in the section 25. So what a situation is. On a successful opposition to the patent under section 25(2), on the ground of wrongful obtaining, the opponent has to file the application for changing the name of the patentee in his favor in Form 12. So, what has happened exactly? A patent was there. Okay? Somebody has wrongfully obtained it. Definitely, it is objectionable. The actual true inventor applies in Form 12 and says the patent office to change the name and name the patent in his name because the another person has wrongfully obtained it. So, but he has to give all the proofs, all the evidences. But the form is Form 12 and it comes under Rule 63. So, Form 12 has to be filled here. So, once we study opposition, there are many rules and sections are given in the Act that we can apply there. And through this, we can understand. Another important thing. Question number 16. Under Section 21J, Section 2 is what? Patentable. Always remember, section 1 says about all definition part, what is patent, who can be the patentee. Section 2 says about what is patentable. Section 3 says about what is not patentable. Okay, so it goes one by one like a process only, and through in these sections are applied. So if we study one by one, things will be applied. So section 2 is about patentability. So section 2 says that what are patentable things. It's all about nonce test, novelty, utility, non-obviousness, and industrial application. So here the non-obviousness means it should have inventive steps, technical advancements. So simple meaning, it should be technically advanced as compared to the existing knowledge. having economic significance, or both, and that makes the invention not obvious to the person skilled in the art. So if you can understand that none's test means none obviousness, you can rightly pick the correct answer. That is, answer is C. Okay. Not obvious, technically advanced, and economic significance. So it is written in the section 21JA. Question number 17. What is an international application? Always remember, international application means PCT application. So Patent Cooperation Treaty allows to file an international application, and through which we can claim the priority date from the international application date. I mean, suppose today we have filed in our country, within 12 months we have to file an international application, and then from the date of international application, we can till 30 months we can enter in the national phase. So it comes in the PCT. Another question, very easy and important, about section 3. So discovery is not patentable. Under which section? Under section 3, that you all know, but section 3C, which says that any new discovery, new scientific theory, anything is not patentable, and so it is not patentable under section 3C. Okay. So whenever we study the section 3, there are many subsections come under 3A, 3B, 3C, 3D. If we can really relate one by one, like what A says, what B says, we can remember what is section 3, A, B, C, up to like section P, K, we go. But but there are many tricks through which you can understand the subsections also, that I can let you know whenever we conduct our sessions. So now, question number 19. Under which section of the Patent Act the examiner to whom the application is referred conducts the examination? So under section 12. Section 11 says what? We file the request for examination. So after filing request for examination, what will happen? Examination will happen. So definitely examination procedures are coming under section 12. So if you correlate one by one, like before what is it was there, after that what it was there, you can find out the right answer. Question number 20. A granted patent gives the patentee the right to claim damage. Right to claim damage from where? From the date of publication in the official journal. Because before publication, nobody can know about your invention or innovation, because it was not in the public domain. So from the date of publication, only the damage can be claimed. Unless until it is in the public domain, you cannot claim the damage. So normally patents are published after 18 months from the date of filing. If you go for expedited, it can be published after 1 week of filing the patent application. But just after the date of publication, you can claim the damage. So it's also like based on little bit common sense that we can apply during exams to answer those things. So in this way, we can have many questions. Now I'm switching over to some of the questions of the second part. Again, you can see this question: an application for termination of compulsory license. So it starts from section 88, 84, and goes up to section 94. So termination of compulsory license comes in section 94. Here also you can correlate your remembrance about it. I told you section 94, normally it is the ending of compulsory license section. So termination of compulsory license is under the provision of section 94. Like you can get some easy questions also. Now, very easy question. A patentee may offer to surrender his patent within a period of any time from the grant of patent. That is an answer. So here the basic fundamental is that we have to just go through what is in the act, what is in the rule, because laws are very straight laws, and if we understand them, we can definitely apply them. So as per Indian Patent Act 1970, patentee means what? A person for the time being entered on the register as the grantee or proprietor of the patent. This is the very logical answer that anybody can answer here. Prior art does not include what? Prior art is what? What is disclosed in publication? What is disclosed in patent? What is disclosed in public domain? So prior publication, prior claiming, prior use. So all three are covered. So what is not in the prior art? Knowledge disclosed only to closed group of members bound by non-disclosure agreement. So that is not a prior art. So definitely it is not in the public domain. So comes now part B. Part B is a little bit a bigger hurdle than part A, because here you have to apply lots of logics. See here. There are situations is that you have to say what is the correct answer. Correct answer A is statement 1 is true, 2 is false. Option B is statement 1 is false, 2 is true. Statement C, statement 1 and 2 both are false. And option D, statement 1 and 2 both are true. So you have, there are two sentences given, and you have to answer either one is true or two is false, or both are true or both are false. So let's see. So always remember these four parts. So while answering, you have to be very careful that you choose the right option. Suppose this is the question, question number 31. An applicant filed a provisional specification and filed a request for early publication before filing the complete specification. His application will be published within 1 month from the date of such request, notwithstanding his failure to file a complete specification till that time. So always remember, early publication request can be filed only after filing the complete specification. This is a very logic that unless until you file a complete specification about your patent, you cannot request patent office to go for publicizing it through expedited publication, means through early publication. So this is a totally false sentence. So we have to write here false first. I suggest you, whenever you answer through the pencil or pen, always write here just on the question paper, so that you can easily identify your option. Statement 2, his application can be published only after filing complete specification. That is a very true answer. So write here true. So what will be your option? Statement 1 is false and 2 is right. So you have to select the option B. So always understand, write here true and false here only, and then select your option. What should be there? So here option B is correct. Question 32. Any person can make a request to controller for mention as inventor in patent any time during the life of the patent. No. Any time during the life of the patent cannot be done. There is a time limit. The mention of any person as inventor under section 28 shall not confer or derogate from any rights under the patent. True. It is true. So another option is B. So in the sections, whenever we study such things, you can definitely understand, you can definitely pick, you can definitely recognize the right answer here. Now another question. If the nature of the biological material is not clearly understood from the description, or not available, not publicly available, shall be completed by depositing the material to an international depository authority under Budapest Treaty. This is a very simple term. Budapest Treaty is for what? Deposition of biological material. And it should not be later than the date of filing the patent application in India. And reference shall be made in the specification within the prescribed period. This is a full sentence given in the Patent Act. Even if you don't remember, just understand that Budapest Treaty is for deposition of biological material, and deposition shall be made not later than the date of filing. So this statement is true. Second statement, you can definitely recognize there is no need of deposition of biological material mentioned in the application and specification. So this is false. You can understand these are very easy question. Situation based, either it would be true or false. But it could be situation when both are true, both are false. So you can see. Convention application can be filed within 12 months from earliest priority date. Yes. From the first filing date, within 12 months, convention application can be filed, right? Second, convention application can be filed beyond 12 months. No, definitely. Patent is a system where 12 months time is a time where it could be allowable. Complete specification within 12 months, convention application within 12 months, international application within 12 months. So always remember this 12 months criteria. Nothing could be beyond 12 months. So this would be false. Option A would be correct. That is, first is true, second is false. Now, the section 1, even in section 1, it is written that application for patent can be done by whom? True and first inventor, or the assignee of the true and first inventor. It is written. So definitely both sentences are true. Application can be made by true and first inventor and assignee of the person claiming to be the true and first inventor. So both are true. So just go to the option D says that both are true. So in this way, there are some questions where you can exactly find out the answers. One question: an applicant is entitled to file a divisional application only after issuance of first examination report. This is false. Applicant is entitled to file a divisional application any time before the grant. Always remember, divisional application is what? We are dividing our own patent application, but it is before the grant of the patent. So sometime patentee may feel that they have claimed two or three type of innovation in a single patent application. They could have filed separate patent application. Sometime controller has felt that application is stating two or three different innovations, and the patentee is filing the like applicant is filing a single fee. Then he may object and say the applicant to divide the application in two or three type of innovations, whoever has been claimed, and file separate patent applications. So, but this all process can be done before the grant of the patent. So, this would be the true one. So, definitely, once the grant is done, then how to divide it? This is a very simple thing. So, before grant only, we can divide the application and can file separate patent application, can pay separate fees. We can have two, three patents like this. One question: an applicant for patent of addition shall be made before the grant of patent for the main invention. Here, patent of addition can be filed before and after grant both. And the term of patent is the same as the parent application. So patent of addition is what? Somewhere innovator has felt that there has been more technical advancement observed, but after filing the patent application. Sometimes he felt that after grant also, like some more, because research is what? It's an ongoing process. So somewhere after 2-3 years, he have observed something better, something more technically advanced. So he can file a patent of addition, and that can be done before and after the grant of the main invention. The lifespan is the same as the parent application. Second option, patent for the main invention is granted after the grant of patent of addition. Definitely not. Patent of addition, you can say that this is a child of the main application. So how could be is like patent of main invention is granted after the patent of addition? Never. Patent of addition is always after the, before or after the like grant of the main invention. But it will follow the main invention. It can never be like before the main invention. So you can easily identify that it is a false option. So option C would be the correct. Both are false. Now, request for examination for patent can be filed by any interested person. Yes, examination can be filed by inventor, assignee of the inventor, like if suppose two or three applicants are there, by any of the applicants or by any other person also. So this is the true one. Another is request for examination can be filed only by applicant, inventor or assignee or no other person. This is false. Any other person can also request for examination. So first is true, second is false. In this way, there are some questions. Now we have entered the part C. You can see here question, the level become little bit more tricky, because not only one answer but even 2-3 options can be simultaneously correct. So if any person uses on his place of business the word patent office, or claims to be falsely claimed to be a patent agent, so he is punishable with what? Imprisonment for a term which may be extendable up to 6 months, or imprisonment or fine, imprisonment and fine. So or and both are applicable. So these all three are correct. You have to carefully read the answer. It is either imprisonment or fine or both. So all the three are correct. So now this is a question where you have to apply some logic. The section number 42. Dates are there. Always like use paper and pen to solve such questions. Provisional application was filed in India on 1st January 2010. Another provisional was filed on 1st March 2010. Thereafter, due to request of the applicant, the controller allowed to cognate both the applications and allowed to file a single complete specification. Which of these are valid dates with regard to submission of complete specification? So, this would be 1 2011. Clear? Because it was first filed in India on this. So, exactly 12 months is the valid date under which the complete specification can be filed. And this is 1st March 2010. It was filed on 1st March 2010, means like 2 months after that. So what could be the valid date? 31st December 2010 would also be the valid date because it is within 12 months. So within 12 months, any complete specification could be filed. But you can see here 27 to 2011 or 1 to 2011. So it will not be a valid date because these are dates after 12 months. So always remember within 12 months, what are the valid dates? You have to just calculate and pick up the right answers. So somewhere things are like tricky or logic, you can say. It's a very important question. Definition of startup. So startup definition is already there in the books. It was an old definition. Nowadays it has also been changed, so we can update with the new one. Earlier it was more than 5 years have lapsed from the date of incorporation, working for the research, development, commercialization, and turnover must not exceed 25 crores. So these three were the options. This is a very like question that is given anywhere in the books that we can go through. So in this way there are many questions here. You can exactly find out the answers. So this is a question now. I can just say that it is related to one of our true false. X and Y make a patent application in Indian Patent Office, naming A as the true and first inventor. The application should be examined when. So there are two applicants. Clear? Two applicants X and Y. Who is the true and first inventor? A. So, who can file the request for examination? X, definitely an applicant can file the request for examination. Y also, because Y is also an applicant. Now, A is the true and first inventor. He can also file the request for examination. And another interested person also can file a request for examination. Always remember, applicant or inventor or any interested person can file the request for examination. So, all four options are correct. So there are some like questions you can easily answer. Now I am switching over to the paper 2 because I wish to let you know about some of the descriptive case studies kind of questions. So now we will enter in our PowerPoint presentation. In that we will learn about the paper 2 questions. So paper 2. Now paper 2 consists of three parts. Part A 20 marks, part B 30 marks, and part C 50 marks. So all questions in part A and B are compulsory. These are question answer based answers. Part C comprises two questions. It is of 50 marks. One question is of 20 marks, and another question is of 30 marks. So in this part C1, it is consists of two questions. Among them, the candidate has to answer just one. So this is about claim drafting. You will be given two questions of claim drafting. One would be a small invention, small description of 20 marks for which you have to draft the claim. Another question is also of a description, but this would be a large description with some drawings, some complicated way, and here you have to draft the claims also. So but in part C there would be two descriptions would be given, you have to select just one. Part C2 also consists of two questions, two big description, you have to select one. So here you have to draft the claims for two inventions, one short invention and one big invention. And there are two options. But I just want to say one thing is like you have to read it very fastly. You know, sometimes what happens, actually there are four situations, four descriptions are given, and you have to select only two descriptions. Clear? One for C1, another for C2. But you have to read it very fast, understand. Sometimes you have to understand your domain. If it is your domain, it will be very fine. If it is not of your domain, like both the situations are out of your domain, if you are supposed from chemical engineering and both are like mechanical or civil, so it's very you have to find out your interest. Just go through it fastly. See, whenever it suits you, it is about your interest, or you can understand it in a glance, pick up that. Because if you waste time in reading the full description, you will not have time to answer it. Because you know, paper 2 is a paper where you have to be very fast, right? Because very lengthy paper, you have to write a lot and you have to manage the time. So time management is very important here. Read the description fastly, decide, and start writing. And never change your mind that I will go to another question, because definitely it will be a lapse of time for you. So now see what are the questions. So first we will see the part A, 20 marks, where we have uh, five questions, four questions of 5 marks each. So you have to answer four questions, compulsory question, there is no option, and each question consists of 5 marks. So here you have to write what is just relevant. Do not be very lengthy. Try to write down the sections if you remember. If you don't remember, no issues, but at least you should write the correct answer. So at least you can get some marks. So the question is, A and B are co-inventors of a tracking device. A files an application for a patent. B comes to know that this has been filed, but the name of B is not in the patent. So this is a total case of what? Wrongful obtainment. Both have done something together, but A has filed the patent and couldn't include the name of B, intentionally or unintentionally, whatever. But it comes under the category of wrongful obtainment of patent. So what B can do? Because how like he can go through this injustice. So what can be done? Sometime whenever it has been done that name is excluded by the A and B is not included, so it comes under the provision of section 28.3. So 28.3 says that if any person other than a person in respect to whom a request in relation to application in question has been made under section 2, subsection 2 is there, desires to be mentioned, he may make a claim in the prescribed manner in that behalf. So if you don't even remember this full sentence, at least if you can write that yes, justice could be done in the favor of B as per the section 28.3, because there is a provision which says that if a name is not included, it is excluded, definitely application can be done by the claimant to include the name in the patent. So in this way you can write. So this claim has to be made in form 8. So whenever we study this such situations, you can like we will also study what are the forms, what are the type of sections, we can remember such things. So form 8 has to be filled, payment of 800 rupees has to be done. You know, form 8 is like for inclusion of names, something is missed and we try to include, we try to add the names, we can fill the form 8. And any amendments, such kind of amendments normally have a fee of 800 rupees. So this you can apply. Like there are many such kind of amendments where the fees are almost the same, rupees 800, and form is form 8. So it should be sent to the controller of patent. Definitely anything has to be sent to controller of patent, and as well as to the person interested. So copy would be sent to the person interested also. And section 28 also says that claimant has to be heard. So you can write your answer as such: yes, I can make an application in form 8, can pay a fee of 800. This has to be sent to the controller of patent. Copy is to be given to the claimant, to B, and yes, claimant has to be heard also. Means it would be given an opportunity by the controller for hearing for B, so that he can state his point very well to the controller. So in this way you can handle this question. Now it comes as Y owns Indian patent, X request for license. So it's a case of licensing. Y imposes certain condition that X cannot. So it's a revision of terms and like conditions. It doesn't like imply. Then Y also impose a condition of exclusive grant back in the license. As an agent, what do you think these conditions are appropriate? Give your answer by relevant provision of the Patent Act. So this is like a 5 marks question. So you have to write exactly what is asked. So the Patent Act says what? When some conditions are unlawful, when imposed by a patentee on a licensee, then such conditions express meaning of some restrictive condition that have to be avoided. These restrictive conditions are given in section 140. Clear? Section 141 and A. If you don't even remember 1 or A, even if you write section 140, that would be okay. So it prohibits the patentee from regulating or restricting the purchase of article covered by the licensee. So section 140 clearly instruct the avoidance by the patentee from imposing a exclusive grant back. Hence, the condition imposed by Y on X will be deemed unlawful. So if Y is imposing certain conditions on X not to acquire, then these are unlawful as per the section 140. So you have to write your answer like this only, just the answer, just the name of the section. So these are all given in the Act. Whenever we will study in detail, these things will be very familiar to all of us. Now some situations, I'm giving you like a situation of PCT. Here there is a question of PCT. This is a very easy question. Suppose some inventor has filed an application in India and approaches immediately thereafter filing international application. What are the questions? Whether he can claim priority of his application filed in India within what time? 12 months, right? 12 months as per PCT. Question B, when he can file a national phase application, 30 months. Always remember, it's a 30 months time to enter the national phase. In India, it could be further extended by a month. So 31 months from the basic application. And the third part, after filing of national phase, what would be the fate of previous application? Means a request for, definitely, what is the fate of a patent application? It is examined and it is already being published before 30 months by WIPO. So publication phase will not be there directly in the national phase. Examination of patent will take place. So in national phase, what will happen? Just the examination. And examination, request for examination is always under section 11. Remember, request for examination section 11 and examination procedure section 12. So under section 11, request for examination can be filed. So very easy question. Do not write anything unnecessary. Just
hello, everybody. Yeah, sorry for the inconvenience. Actually, I think that there is a power cut from the side of ma'am. So we'll wait for her while she gets back. But meanwhile, I can apprise you about the 8-week course that we are starting on 29th of of January. That means exactly 2 weeks from now. So ma'am has, meticulously planned the whole session. And okay, ma'am is back actually. So I will let her complete her session before giving you the entire breakup of the 8 week course that ma'am has planned. So ma'am, welcome back. I'll get you back on the stream.
Yeah. Yeah, sorry for a little interruption. So, yeah. So let's continue with this. I hope like participants must be enjoying, they must be understanding the things well. Definitely, the Patent Act is a little bit has to be understood like a story only. And yeah, I'm continuing with the questions. So, in this way, we have to answer our questions. So, we have understood all this thing. Startup also we have gone through. So, the like there are many terms. One question is was very interesting that has been asked about section 3D. So it was a question which has said that all the salts, ester, ethers, particle size, isomers are not considered to be patentable unless until they differ with regard to efficacy. So explain the term efficacy. In the judgment of Supreme Court in the matter of Novartis versus Union of India. So there are some cases that we study like a epic case, like Roch versus Cipla, Novartis versus Supreme Court of India, as per this imatinib mesylate case. So this is such a case which is like a big story, and this is such an interesting story of a case. Is like section 3D because it was a long battle with the Supreme Court. Still, it was not accepted. Why? Because it is a beta crystalline form of imatinib mesylate, that is a salt form, and Supreme Court said that no, it is just the same substance, because this Gleevec has been filed by Novartis before 2005. In 2005, when Section 3D was introduced, there was a big hurdle in getting the patents because of this Section 3D. Indian government was very strict about this Section 3D and didn't allow Novartis for the patent. Novartis went to High Court, went to Supreme Court. Long battle was there. It was an epic case by the Supreme Court, and that's why I think nobody can miss this case. And such situations are asked like that. You will never be given a very unknown case. You will given such a epic cases which we will be knowing. Important is that you can understand those cases and can find out like where the points are there. So in this way you have to uh, write the answers. So these things are very common, means like these common things you can definitely understand and write it. Now I'm giving you this is a question, actually this is the claim. Such situations will be given to you in the part C. Part C1, again two situations. Part C2 will have two situations. In part C1, there are two descriptions, short descriptions like this. You have to read it fast, find out like really you can understand it or not. Then you have to provide an appropriate title. You have to draft an abstract, and you have to draft 5 claims that I can very easily make you understand how to do it fastly in just 5-10 minutes, then how to write the title, abstract, and claims in just within the stipulated time. This is a trick because major people cannot go through in the paper, like cannot pass in paper 2 because of the situation, because there are a lot of wastage of time. So just understand, there is a proper trick. We can practice it during our sessions. Actually, one by one, we can mentor. And there are, like you can see here, like or. So there are two situations. Just read it in 2 minutes. Again, read the another one in 2 minutes. Decide and start writing. So definitely, I can mentor you for this in our session. So in this way, we can solve our papers. And yes, it has to be made interesting so that you can enjoy your journey of patent agent exam preparation. Also, you can enjoy your exam, and also you can enjoy your viva, so that you can definitely go through this exam and can definitely become a patent agent for the next year. So Wish you all the best. Best of luck to all of you for your preparation. Yes. Over to you, Mr. Rahul Kapoor.
Thank you, ma'am. Thank you so much. Really, really pleasure to have you. And so, folks, everybody, I will share my screen and I will show you exactly what ma'am has, planned like a systematic, 8-week program. So, yeah, just give me a moment. All right. All right. I hope you can see my screen. So in this course, okay, as you would have understood by now, patent agent exam preparation is very messy. Okay, so you need guidance of the section. There's like literally like 90 plus sections, and ma'am would have also told you that you also need some tips and tricks. That there's a lot of chance that you can lose time. There's a lot of chance that you will basically waste time in preparing. So basically, to prepare, you in the most efficient way. So I'll just show you. So first of all, about ma'am, I think ma'am has not mentioned all these things, but she is one of the leading IPR instructors in India. She got A++ grades in Nalsar Hyderabad, and she was like the top rank in the whole country in IPR laws. So the key highlights about the 8-week session. It's going to be 8 weeks. Actually, it will be more than 8 weeks because we will also have free sessions at the end, like a crash course. So approximately it will be 4 hours per week, and there will be 30 hours. So basically, folks, ma'am is going to give you 30 hours, and that 30 hours will save you hundreds and hundreds of hours. So if you are really planning that you are giving the patent agent exam this year, and you would like guidance, so I would say it's a really no-brainer. Just go with this course. So I'll just show you all the details. So it will cover everything. Okay, ma'am and Turnip together, our job is to maximize the possibility of success. So we will make sure we prepare all the material, we prepare sample questions, and make sure that it's like full support. So I don't want to get into details like there'll be this or there'll be that. So MCQ problems, solutions, patent act, step by step, practice questions. Primarily, we will have the same format in YouTube. We'll have private videos, so only the people who've paid can access it. And also, we will have Google Meet sometimes to have it more interactive and have a bit of a like a one-to-one guidance. So as I have already mentioned, it starts in 2 weeks, 29th of January, and we will also have a WhatsApp group to share reference material, so that there's always context of what will be covered in the next session or the next session, and so on. So a quick breakup. Paper one, which is the Patent Act. Actually, you have to be very, very good with Patent Act. So the subsequent paper two automatically gets easier. So if you have a very good understanding of the concepts, paper one helps a lot in paper two also. So paper one would be 6 weeks, section by section. So at the end of this PDF, ma'am has also mentioned how the 6 weeks are are broken up.
Yeah.
And every session there will be live MCQ, so that you are staying in touch. There's going to be learning material, and approximately there will be 20 sessions regarding paper one. This will be followed by paper two. So practice of explanatory questions, case studies, like some of the things that ma'am has shown, live assignments, discussions, and even how to write patent claims. So on all those sections, there will be like about 6 sessions. And towards the end of the course, end of the like just before the patent agent exam is there will be some free sessions. They will be actually paid sessions, but for those who are registering for the 8-week program, it will be free. So we will have about 3 crash course sessions that will be paid for like general public, but for the course participants, you get it like free. So the price, we have priced it at like 15,000 rupees, and that includes all the 30 hours of what ma'am is going to give you, and all the support that we'll give you, all the material and all the sessions to help you basically succeed. But if you decide today, since you have already likely have seen ma'am take other sessions with us, so you would have already known us. So if you are, for sure that that you want to do this and you want to go with these 8-week sessions, you can save 2,000 rupees if you just decide today that you want to go with this session. So I would like highly urge you to go with this. So it's not like at 12 o'clock it will end or anything. So tomorrow I intend to make this again like 15,000 rupees. So please decide. And like I said, it's a no-brainer if you are thinking of the patent agent exam, and if you are you need this guidance. So the payment is like from Razorpay. You can pay. So if you pay with Razorpay, we will give you an e-receipt. And but if you are a registered GST entity, or if you are looking for a GST invoice, you can also then you should not pay with Razorpay. So you can pay. We will still offer you something, some GST invoice, but I would prefer you pay via UPI or net banking. So folks, that's it. These are some payment terms. So we will send you all these details via the email after the session. And if you want to see, you can also see how the 6 weeks are divided for Patent Act, and how it's divided for the paper 2. And yeah, so if you have any questions, actually you can also ask ma'am if you
Yes,
yeah,
yes,
yeah,
please.
ma'am. So if you can just see any questions if you want, we can.
Okay. One question is, can you brief about Viva? Yes, yes. So Viva is that whenever you reach the like patent office and enter your interview room, first of all, what is very important that you have to be very confident what you have studied. Somewhere, if you don't even remember the section, always remember what is there in the section. So suppose somebody give you a situation like I have been given a situation is like, suppose you have filed a patent, later on somebody else claims to be a part of that we had just discussed. Like we can include the name of that person. This was a situation. I have been asked about the PCT application, how the timelines are there. Then I have been asked about addition or substitution of applicants. I have been asked about section 3D. I have been asked about non-patentable, patentable. Questions are like, and always remember, always study some recent amendments that have been done. Suppose they have asked me what is the being a woman, what would be the benefit that you can avail out of that. So recently, just 2 months back or 1 month back, the inclusion of women to avail the benefit of expedited examination was there. So I answered that yes, being a woman, I can get the benefit of expedited examination at the fee of like a startup. So be like very much read the sections, subsections. Always study what is the recent amendments. Be very like study the recent current affairs in patent also, and you have to be very confident whatever you have studied you tell them. Even if you don't understand, don't remember the section that time, but try to state what is there in the section that I'm trying to convince you. It's like you understand the process, you understand the basics, and try to answer your questions. So in Viva, even if you don't remember, because sometimes something doesn't strike, sections are many, subsections are many, many rules are there, but you have to remember what is there in section. And one by one you will be going to understand and remember the sections also, that you will really realize after 2 3 months of preparation, you will realize that you are now very much comfortable with the act. So yes. Any other question is there? I will be really happy to answer, or we can discuss in our later sessions also. You can every time, anytime clarify your doubts.
All right, all right. Thank you, ma'am. Thank you so much for your time. And folks, everybody who has joined us, we will send you all this PDF that I was showing you. We will send you via email. If you have any questions, please respond to the email. And please free to get in touch with me. Also, I will give my phone number. So I am like really looking forward to have you on in our 8-week program. So for now, have a great evening, and see you in our future sessions. Bye bye.
Thank you.